Good afternoon, everyone. Happy Friday. Thank you so much for being here with us today. I'm going to take it slow with these introductions, let folks trickle on in because we have a lot of folks registered for today, and I see the numbers increasing on our participant list. So welcome to Full Disclosure, Understanding the Responsibilities of Buyers and Sellers in Real Estate Transactions. I can't thank the speakers that we have here today enough for coming to talk to us about this topic. For those of you who don't know, this topic came to fruition from one of our legal aid organizations that has encountered issues on this topic more frequently, given the changes in the real estate market and the housing market post-COVID. And I didn't know anything about it and didn't know what to do. And so with that, I give a very special thanks to the Real Property, Probate, and Trust section of the Florida Bar for jumping in and saying, yes, we will donate some of our time to teach legal aid about this important topic that they need training on. So thank you to our speakers. Thank you to the section. Before we move into this discussion and this training, I always want to give some housekeeping announcements. First and foremost, this is being recorded. Thank you to our speakers for giving us that permission. You will be able to review this content later on when that problem in that case comes up or as you need. So it is being recorded. Secondary housekeeping announcement is CLE credit. As you all know, I always work to try to get you CLE credits when it comes to these awesome trainings. And I'm really happy to say that this was approved for CLE credit, and I will be announcing that CLE code at the end of the presentation, and I will pop it into the chat as well. Third piece of housekeeping announcements is closed captions. Closed captions are on. If you have any trouble enabling them, please reach out to me separately in the chat. But you should be able to click more, show captions for anybody that needs that additional accessibility. Final piece of housekeeping announcements are questions and answers. I know I say this all the time. Those of you who come to a lot of my trainings are probably really tired of hearing me. I'm tired of hearing me. But please get involved. Ask us your questions. Put them in the chat or the Q&A. You might have the burning question that somebody else sitting in the virtual vortex also has. So don't be shy. Pop it into the chat or the Q&A. And at the end, if time permits, I'm going to read your questions out loud to our speakers to answer. So don't be shy. I know it's tough and I know it's Friday, but we want to hear from you. So I think that's all the housekeeping announcements that I run through on a regular basis. At this point, I should have a checklist. I don't know why I don't do that. And with that being said, I am going to turn it over to our speakers to give us a brief introduction about themselves and then move into the content. John, Colleen, Kristen, thank you so much for being here. The floor is yours for whoever wants to go first.
No one's going first, so I'll go first. I'm Kristen. We'll go in speaker order. I am a attorney that I work down in South Florida. I generally work with real estate brokers, and I do a lot of broker representation type of work, both in helping brokers through transaction issues, their commission disputes, and FREC complaints and DPPR complaints and things of that nature. So I'm so excited to be here today. The roadmap for our presentation, we have an outline that's going to be dropped into the chat, but I'm going to start by talking about realtor duties and some of the forms and the disclosures and things that should occur during the transaction, which is kind of the contract phase before closing. And then we're going to go into the contracts with Colleen. So I'll let her introduce herself last. And then the last part of the piece is going to be talking about claims in the event there was some sort of failure to disclose it and there's a proper claim under the various cases that set the framework for those types of cases. And John's going to do that part. So it's going to be me, then Colleen, then John, and then we'll do questions at the end. Each section kind of builds on itself and there's overlap. So I just let you know that because I'm going to talk about things that Colleen is, and then the same thing with John, where it goes back and forth, but we're going to try to do it in that order. So Colleen, do you want to go next?
Sure. Hi, I'm Colleen Sachs. I am located in the Panhandle, and I am a senior commercial underwriting attorney with Attorney's Title Insurance Fund. But I worked for 30 years. I was in private practice, and I did both commercial and residential transactions. But my entire career has been focused on real estate, and I'm looking forward to talking to you today about disclosures that are seller disclosures primarily in the FAR bar contract, or the Florida Realtors Florida Bar standard and as is contracts, which, by the way, Kristen and John and I all serve on the committee as attorney members of the committee, along with other attorneys and Florida Realtors, to actually draft that contract. And
But don't blame
all three
us
of
for
us. Don't blame us if you don't like it, but all three of us have insight into the contract that is better than a lot of people, because we see how it's made. So.
I'm John Redding here in Tampa, Florida. I do a lot of work with brokers and agents, sort of like Kristen does, representing them when they have issues with contracts, things such as that, listing agreements, etc. Prior to becoming an attorney, I was a commercial title examiner and had been involved in the title insurance industry since 1988. Went back into the title insurance industry after becoming a lawyer as underwriting counsel, and went into private practice in 2008.
All right, thank you. So I think I'm up first. So I'm going to dive into, so our understanding of what the issue is going on is there's transactions are closing, and then you're getting calls from buyers saying something happened in the transaction. I wasn't aware of an issue. What's my remedy? So we're going to start by taking going back to the transaction when the realtor was involved. So the realtor typically gets involved when a buyer is starting to look for a home. In the state of Florida, real estate agents are regulated under Chapter 475, Florida statutes. And there's different types of relationships. So the first thing I'm going to do is just share the default relationship. So unless the parties agree otherwise in writing, it's going to be, oh, wait, hold on. Did I just share it?
Yep, you shared it.
I'm sharing. Okay. So unless the parties agree otherwise as to the type of relationship that's in place, the default relationship in the state of Florida is considered a transaction broker relationship. The statute outlines what duties a Florida real estate licensee has when they're serving as a transaction broker. And I'm highlighting the one that's most important here for the purposes of our discussion, which is that an agent has a duty to disclose known facts that materially affect the residential real estate or value of residential real estate that's not readily observable to the buyer. So the crux of all this conversation is going to rely on what has to be disclosed in transactions, both by agents and by sellers. So the other two types of relationships that could be in the state of Florida is a single agent and no agency relationship. Those two also have duties of obligations to disclose. They vary based on how the duty of confidentiality that is owed to the seller when they're representing a seller, but there is a duty to still disclose material defects that are not readily observable to the buyer. So the first thing I like to say when I'm talking about this topic is that, yes, there is a duty, but real estate agents don't necessarily know of defects. Real estate agents aren't inspectors. They're not contractors. Typically, they're not going to know of known defects, especially if they're not visible. So how does a real estate licensee become aware of a material defect? So there's a few ways, one of which is the seller's disclosure, which we're going to talk about in a minute. And I know Colleen's going to talk about it too. The seller's disclosure is a document that I teach agents to obtain a copy of, it's produced, different brokerages either produce their own forms, or Florida Realtors has a form, which is the form I'm going to share. But this is a document that there's different versions of it here. Let me pull it up so we have it to go along. Okay, so there's different versions of this form, but this form, there's a condominium version and there's a single family home version. So I included both copies here. This is the condo version. This is the single family home version. But what the form does is it asks a lot of probing questions to a seller to try to pull information from the seller on what's going on in the property. So you'll see lots of questions here. There's always room for narratives if there's details that you have to get into. And it kind of goes through all different parts of the property. You'll see Johnson v. Davis is footnoted here. John's going to get into that a little bit later on. But these are questions that are asking for specific information to the property that will help pull out the information as to what's going on in the property, because there might be things that a real estate agent isn't going to know. The issue with this form is that it's not a required form to close. So it's not always filled out depending on the real estate agent you're working with. I suggest agents have it filled out because I think it protects them too, because they have actually something in writing where seller says what's going on and what's not going on in the property, but it's not always filled out. The other issue is sometimes you have sellers who actually don't know what's going on the property. The example of that happens when, say, someone passes away, an adult child who's never lived on the property obtains ownership of the property and now is selling it. They don't know when the roof was last updated. They've got to dig through records. They might not even have all this information. In those situations, I think the sellers are pretty reluctant to fill these forms out because they've never occupied the property. So they really don't know exactly what was going on and what maintenance was done. So the seller's disclosure is a good form both for the parties to the transaction because it gets all the information out in the open, but it's also good for brokers because now they have an actual document to rely on to show what's going on in the property and what's not. So I'm going to stop share real quick. So where real estate agents I find get in hot water is when they, number one, don't use the form. And number two, somehow through some way they come into access of the information that materially affects the property. So if you just take a listing and nothing's readily observable and no information is told to you, the real estate agent might not actually have any knowledge that they have an obligation to share under the licensing rules. But where this comes up and where real estate licensees all of a sudden do have information is sometimes the example I see it happen most often is when a transaction is happening. So a listing agent has a property, they're listing the property, they're getting ready to sell the property, and the transaction goes under contract with a buyer. The buyer starts to do their inspections and they find something wrong with the property. And the buyer forwards the inspection report to the listing agent, and now the listing agent has a copy of it. So now they're in a situation where they maybe didn't know of a material defect, and now they actually see the inspection report. In that circumstance, what I always recommend is that the buyer's agent, the listing agent, have a conversation with the seller and say, this is what's going on. We need to figure out if there is a material defect. And if there is, we have to figure out how to properly disclose this to subsequent buyers. So it may not necessarily, if it's found in that transaction, it's not an issue, but then for subsequent transactions, it could become an issue. So a quick note on the seller's disclosure. There was a case that came out last year. I think it was last year. Yes, it's in your materials. It's the Sage case. The Sage case is super important. John's going to talk about that one too. But in that case, there was a claim by a buyer for failure to disclose. And in that case, the seller had completed a seller's disclosure, and the material defect at issue was disclosed both in the seller's disclosure and came up in the inspection report. In that circumstance, the seller or the buyer wasn't able to recover any damages for failure to disclose because it was included in both the seller's disclosure and the inspection report. So it's a really good case. I recommend everybody read it. We can't go through it in detail today, but read through it because it talks about how that disclosure was made, and it's really important to understand and to ask for those things when you're working with clients who think there might have been a disclosure. So a quick note on inspections. If you're working with a buyer and you want to know, they're trying to figure out if something wasn't disclosed or if something wasn't located. One of the things I know Alexis had asked us to talk about was whether inspectors have liability. Inspectors are also regulated by DBPR. There's links in your notes for both. If you do think there is some sort of complaint either against a real estate licensee or a inspector, there's a link to where you can look at the licensing rules in your materials. For inspectors, I just want to make a note that inspectors are great, but you also have to look at what inspections were purchased by the buyer. If if a buyer is using typical financing, there's going to be certain types of inspections that have to be done by their lender. It's typically a 4-point inspection, which is going to look at electric, plumbing, roof, structure, and HVAC. But you have to see if they actually located other or purchased other type of inspection reports. The one inspection I can think of that a lot of people don't always purchase and then they find out there's an issue of is mold. So Colleen's going to go over the mold addendum, which is a specialized inspection, but that's one issue that might not typically have been covered in your inspection report that maybe becomes an issue after the fact. So you have to look at what exactly the inspector was asked to review during the transaction. Okay, so the final part for me, I want to talk about the pre-closing walkthrough. So during the transaction, how the transaction typically goes around is that a purchase of contract agreement is executed, which Colleen's going to get into next. Then it goes into an inspection period, depending on the contract used, depends on what the period of due diligence is and what inspections are obtained. And then if there's an inspection period and there's a right to cancel, if it goes beyond that, then the contract is set to go to closing. There's other types of contingencies, but from a due diligence standpoint, the due diligence period ends and then the transaction goes to close. During the due diligence process, it's typical to locate issues on the property and try to negotiate them. A pre-walkthrough right before closing always gives the opportunity for the buyer to re-inspect the property, whether they're re-inspecting things that were supposed to be repaired by the seller, or they're just making sure the property is still in order. There's always an opportunity for a walkthrough right before closing. It's built into the contract. And another case that came out, I believe it was last year, was Smith versus Carlton. That case walks through a situation where a walkthrough kind of went sideways. There was work that was supposed to be done by the seller didn't complete it. The walkthrough was complete. The buyer said, you didn't complete the work you were supposed to do on this property. So typically at a walkthrough, if you locate issues on the property, it would be wise to try to address those before you go to closing. But it's not always capable of doing that before closing. So in those circumstances, sometimes a buyer will say, I want the seller proceeds to hold back a certain amount of money in escrow to allow these changes or these repairs to be made, something to that effect. But the Smith versus Carlton case was really interesting because they tried to argue, the seller tried to argue that because the buyers closed the transaction after going through the walkthrough, that they waived their rights to argue all the damage that they found during the walkthrough. And the court said no. The court said, just because you went to closing doesn't necessarily mean that you waived your rights. There's a lot of factors that go into waiving a contractual right, and just proceeding to closing doesn't necessarily mean you waived the right. That's also a good case to read through because it outlines exactly, there's a lot of specific facts as to how the buyer represented their rights to enforce the contract, which is what the court relied on to say they didn't waive their claim just because they closed. Okay, I went a little bit over, but Colleen, do you want to start?
Yes. Let me get my video going. There we go. Yeah, so I'm going to be discussing the disclosures that are found in the contract form. We have for the Florida Realtors Florida Bar contracts, which are known as the FAR contracts, we have the standard contract and then we have an as-is contract. The current version of each contract is version 6X. So if you're viewing this on a recording, the contract changes from time to time, and you'll want to make sure that you look down at the bottom left corner, I believe, of the contract to make sure that you are dealing with that version, so that because something may have changed. And we actually have had a couple of fairly big changes this past year. So the first thing to do is understand that the three of us, as I mentioned, are all part of the team that creates this contract. We try to create the contract using as plain language as possible, and there's no substitute for reading through the contract. But when we're dealing with disclosures, the first place we're going to go in the contract is to Section 10, which is aptly called disclosures. And the versions of the contract, the two versions, are identical in a lot of respects, but they do differ in some respects. And those areas I'll point out when we get to them. So the first disclosure you find in Section 10 is rate on gas. And this disclosure notes that rate on gas is that exceeds the, sorry, just one second there. This that rate on gas that exceeds the guidelines that have been set by federal and state have been found in buildings in Florida, and it directs buyers to the county health department to get more information on these guidelines. I have somebody that's trying to call in, and I apologize for that. I'm going to disconnect my phone. The permits and disclosure says that there is a written disclosure by the seller, and that's what Kristen just discussed. It indicates that there are no improvements that were made without required permits, and that there are no open permits. It also requires the seller to deliver to the buyer information that the seller has concerning permits that are not closed and unpermitted improvements. So it doesn't make them go out and get new information necessarily, but if there is information that the seller has in their possession, they do need to provide that information. The mold disclosure. The disclosure language in the mold disclosure initially is the same, but the standard contract incorporates rider I. And that rider, which is in the materials, provides that the buyer, at the buyer's expense, may have the mold inspection conducted by a professional. It provides a time period of 20 days, unless another number of days has been entered in the blank in the form. And it provides for remediation and repair costs. And it defaults to $500 unless another amount is entered. If the cost exceeds that amount, the buyer can cancel the contract and receive a return of the deposit. And if the buyer doesn't conduct the inspection and notify the seller in a timely manner, then that mold contingency is going to be waived. Timing on all of this is very important. When the contract calls for a specific time period, be aware of those time periods. People that do closings tend to make lists and checklists of when the different times expire and put notes in their calendars so they don't have an issue with the time expiring and missing potentially the ability to object to something that is a contingency. The flood zone and elevation certification. This is a disclosure that lets the buyer know that it's the buyer's responsibility to confirm that the flood zone of the property what the flood zone is of the property on an elevation certificate. And you'll see elevation certificates and you'll see this information on surveys or in a separate elevation certificate a surveyor may provide. And they also have to determine whether flood insurance is going to be required by their lender and whether there are restrictions on building and rebuilding in the event of a casualty. As we see around the state, more people planning for the potential of a hurricane and planning for resiliency. We see that there are codes that say if a building is destroyed in one place, it may not be able to be built back or built back in the same way. So if it's in a particular flood zone or at a particular elevation. So it's important for the buyer to know this information. The disclosure provides the buyer the ability to terminate the contract if the property is in a certain protected area and the lowest floor elevation is below the minimum flood elevation, or it's not eligible for flood insurance. The default time for that termination is within 20 days after the contract's effective date. You can enter a different time, and it's important to be sure that that flood certification is going to be available prior to that deadline because it is a big deal and is becoming a bigger deal. The energy brochure. This disclosure makes the buyer aware that they should have received the Florida Energy Efficiency Rating Information brochure that's required by statute. And the lead-based paint. If the property is housing that was constructed prior to 1978, a lead-based paint disclosure is going to be required. The HOA and community disclosure lets the buyer know that they shouldn't sign the contract if the property is in a homeowners or community association, and this is going to include condominiums and subdivisions that have an association that governs them, until they've actually read the homeowners or community association disclosure. Those are going to be attached as riders to the contract, and I'm going to talk about those in a little more detail in a few minutes. The property tax disclosure summary. This disclosure warns buyers that they shouldn't rely on the property taxes that have been assessed to the seller, because that amount can change when the property is reassessed after the transfer. And this is really important when you're dealing with property that, say, is a first sale out of a condominium unit, or a subdivision, a house in a subdivision out of a developer, or where a seller may have owned the property for an extended time, or where property was vacant and then recently has something constructed on it. Because the following year, those taxes can increase significantly. Our taxes are assessed on January 1st of the current year. So they're paid in November of that year, they're paid in arrears. But whatever the status of that property was on January 1st, is the status it will have for that tax year. So if the property didn't get a certificate of occupancy, say, until after January 1st, it will have been assessed as vacant land. And so whoever's paying taxes on it now is going to be paying taxes at a very low amount. Well, when the next tax bill comes around, the property is now no longer vacant land and it's worth more. Or if it's somebody that's lived in the property for a long time, it's been assessed at a lower amount because of the Save Our Homes initiative, or that the property can't go up, the taxes can't go up more than a certain percent each year. And all of a sudden you have a buyer that was paying tax escrows to their lender on a very small amount. And now that amount has increased. They have to pay it on the new increased amount. Plus, they're probably going to have a shortage in their escrow that they're going to have to make up. And I've seen situations where buyers all of a sudden can't afford their mortgage payment anymore because now they're paying taxes at what the real amount should be. So just be really aware, if you're dealing with a buyer, that they shouldn't rely on that property tax that was assessed to the seller, because that amount's going to change most likely. The Foreign Investment in Real Property Tax Act, or FIRPTA, disclosure. This disclosure discusses the responsibilities of the parties in connection with the act. It advises the parties to consult legal counsel, and then it references Standard V in the standards section of the contract, which is at the end of the contract. It has a lot of information about FIRPTA in that standard. And it's important for the parties to be aware of how FIRPTA works. If nothing is withheld from the seller's proceeds, and it turns out that the seller was subject to withholding, the buyer may be required to pay that tax. And the seller is likely no longer in the jurisdiction. They got their money from the closing and they went back to the country that they live in, and you may not be able to reach them. And certainly the IRS can't reach them, so they're holding the buyer responsible for it. So it's important to know, if you're a buyer, what can happen if the proper tax isn't withheld from the seller at the time of the transaction. The seller disclosure section, in section J, is where you find the most important difference between the contract forms. The standard contract reads that the seller knows of no facts that materially affecting the value of the real property, which are not readily observable and which have not been disclosed to the buyer. And except as otherwise disclosed in writing, the sellers received no written or verbal notice from any governmental entity or agency as to a currently uncorrected building, environmental, or safety code violation. The first sentence is referred to as the Johnson versus Davis language. Johnson versus Davis is a huge case, and as all three of us will be talking about it, and it's a great case for you to read and understand. And it essentially provides that the seller has disclosed any latent defects it's aware of. And I'll let John discuss more about that in the next section. Well, the as-is contract starts with that same sentence, but then it adds language disclaiming any warranty. So it starts out and it says, except as provided for in the preceding sentence. So it preserves that Johnson versus Davis known latent defects language. The seller extends and intends no warranty and makes no representation of any type, either express or implied, as to the physical condition or history of the property. This is a significant and an important distinction. As the seller is saying, I'm not warranting anything unless there was something I knew about that was hidden and I didn't tell you about it. So there are other disclosures that are found in other parts of the contract. Just above the signature line is our most recent change to the contract forms, and it's a notice to both buyers and sellers that provisions in the Florida statutes regulate the sale, purchase, and ownership of property by certain buyers from enumerated foreign countries of concern. At this time, there are 7 countries that are named in the statute, and they include China and Russia and the Venezuelan regime of Nicolas Maduro. Those are all countries whose domiciliaries frequently purchase property in Florida. This is a big issue right now. The company that I work for, we field a lot of calls from our member agents that have people that are buying property that are from one of these countries and need to know if they are able to purchase the property or not. So just be very aware that that exists. As you can see in the disclosure, it cites to section 692.201 to 692.205. That's the meat of the act. And if you have somebody from one of those countries that's listed here in the contract, it is well worth your while to read through that act and understand it, or talk to somebody who does understand it. And of course, you're able to contact me. I'm happy to field calls, and I'll give you my contact information in a few minutes. Some of the riders to the contract that contain disclosures. For example, the condo rider discloses whether the association has the right of approval or right of first refusal, the amount of assessments, including any pending assessments that the seller is aware of, and if the seller is aware of pending or anticipated litigation affecting the condominium or its common elements, that has to be disclosed. It also requires disclosure if the association has voted to forego retrofitting for their fire sprinkler system and for handrails and guardrails for units. And it requires disclosure by non-developer sellers, who are the people that are going to be really using this contract, of the contents of the governing documents of the association, by providing the buyer a copy of the documents and giving the buyer 3 days to review the documents, during which time that contract is voidable. And as of this year, there are provisions letting the buyers know that in addition to receiving a copy of the governance form, the buyers are also entitled, where it's applicable, to a summary of the milestone inspection report and a copy of the most recent structural integrity reserve study. Those are both things that came out of recent legislation that regard the condominium collapse in Surfside, and some new regulations towards life safety issues and the integrity of the condominium structure. Likewise, the Homeowners Association disclosure requires that, among other things, disclosure that the buyer is going to be required to be a member of an association, that there are assessments, and whether there are rights of approval or first refusal. If the property is subject to the property assessed clean energy or PACE financing, there's a statutory disclosure contained within that rider. And PACE financing is repaid through the property tax bill, and it has priority over a mortgage. So lenders are generally going to require the financing to be repaid in full before accepting a mortgage for purchase or financing. PACE financing is for things like a new roof, possibly, things that can help protect the property from hurricanes. And people get these loans, they're paid through the tax bill, and a lot of times they think they never have to pay it off. It's just going to be part of their property taxes. And that's okay with PACE, but it's not okay with these lenders. And we've seen situations where the fact that the loan has to be paid off so that a buyer can get financing is often a surprise to that owner. And sometimes that owner has to bring money to closing that they're not able to do. Disclosure requirements are also found in the seasonal and vacation rentals rider. And then related to that rider, in the body of the contract, Section 6 requires the disclosure of leases and occupancy agreements that extend after closing. And within the contract standards, Standard C has the seller represent that there is insurable access to the property, requiring by implication the disclosure of a lack of access. And the same goes for liens in Standard E. So when you're reading through the contract, If there's something that calls for a warranty by a seller and the seller isn't able to give that warranty, by implication, that thing is going to need to be disclosed. So those are some of the big disclosure issues that we see in the contract. And I'm going to turn things over now to John to talk to you some more about his topic.
I had a hard time unmuting. Okay, so I think like everyone has said, there's going to be some bit of duplicativity with this because everything kind of flows together. So just forgive that. When you deal with the disclosures, you have to first consider that, and I'm going to talk mainly about the as-is contract because that's what most people use. The as-is provision of the contract does not contractually relieve the seller from the obligations of disclosure. It merely relieves them from the obligation to repair should they be asked to do so. So that's the first thing you have to really consider. And a lot of people mistake the as-is for as-is where is. And that's really not what it is. Johnson v. Davis and his progeny, what do these cases mean? Johnson v. Davis came out back in the 80s, and it's the first case to address this, getting rid of, let the buyer beware. And basically, it says that the seller has to disclose those defects that are known to the seller. It doesn't mean that the seller has an obligation to investigate to determine if there's any defects, just if they're known, if they're not readily observable. But I would also caution people, disclose them anyway, even if they are observable. It's better to do it that way. There are 4 elements under a Johnson v. Davis claim. First one, the seller must have knowledge of the defect. Second, the defect must materially affect the value of the property. Third, the defect is not readily observable. Now, here's the problem. The courts really didn't define readily observable, and they've been trying to back and forth with several cases. But let's get back to this. And 4, the buyer must establish that the seller failed to disclose this defect. That's the hardest one we have here because nowhere in the law is the seller required to give a written disclosure. It's best to do so, but nowhere requires it to be written. And I always tell people to use the FAR form because it's pretty good, but it doesn't include everything. And if you know of other things, attach an additional sheet. Well, that's getting back to readily observable. It wasn't defined in Johnson, and the courts have struggled with this. Some guidance can be taken from a case, Nelson v. Wiggs, and is cited to in the Pahlavi case, Seifi Pahlavi, and a few others, and I'll be sending those in afterwards. What this third DCA case, and it has received some negative treatment, but it continues to be cited as recently as this year, is that it tries to define what readily observable is. I will say that the case itself, while it's the law, the dissent got it better, but that's a different story. What we're looking at is what you are responsible for doing, and basically it comes down to if it's been disclosed, that's great. If it hasn't been disclosed, but you can discover it by due diligence, it may not bring a claim if you try to raise that because you could have learned it yourself. And that one's covered again in the Seifi Pahlavi case. That one just came down this year and deals specifically with that fact. They did their inspections, they did their due diligence, but they didn't read any of it. Everything was disclosed, and we heard that earlier, but they brought the action, but because they failed to and admitted that they failed to read the disclosure, failed to read their inspection report, their case failed for that reason. And again, like I said, I'll send in those cases, and I'm trying to avoid being duplicative. Non-disclosure and misrepresentation, they're a lot alike, but at times they're different and viewed differently. In the case of non-disclosure, if the buyer could have discovered the defect through ordinary due diligence, this could counter the buyer's claim. And again, it's really hard to go into that. It's on a case-by-case basis. And a lot of these things deal with how observable these things are. Is it public record? Can it be determined? For instance, we have in some counties, Pasco County for one, we have sinkhole notices that are filed for record that will be disclosed on a title search, things like that. Well, if the person who bought the property, say they got it through foreclosure, for some reason failed to disclose this, didn't know it, should have known it, but didn't, failed to disclose, the claim may fail because it's public record and you can determine it. So that's non-disclosure. Defects that are readily observable or within the buyer's ability to easily discover also would serve to counter the claim, such as I mentioned before, the sinkhole notices in Pasco County. There are a lot of other things to disclose that aren't necessarily dealt with under Johnson v. Davis and his progeny. And for that, you need to look at Florida Statute 689.25. As I said earlier, I represent brokerages throughout the state and have represented the brokerages dealing with these cases, as well as some homeowners when there wasn't a conflict. One of the things that I was asked to by one of the brokers some time ago, 8 years ago to be exact, was stigmatized properties and what must be disclosed. Again, this isn't really with the Johnson v. Davis line, but there's still disclosures that must be made. The question that was actually asked of me is, there was a death on the property, do we have to tell them? So if you look at 689.25, it doesn't address a lot of things, but it does address deaths on the property. The fact that the property was or was at any time suspected to have been the site of a homicide, suicide, or death is not a material fact that must be disclosed in a real estate transaction. So again, this is from 2015. I would double check that to see that it still reads the same, but I want to bring that up. Now you get into the issue of AIDS patients and HIV patients. If the property was occupied by somebody that suffered from these maladies, you can't disclose this. And if they weren't, even saying no could be actionable because you're not supposed to talk about this at all. So saying yes or no is prohibited under fair housing. And you would need to say, I can't answer that at all, either negatively or positively because of Fair Housing Act, because this is a class of persons that are protected. Now we get into the more esoteric disclosure issues, and this I had fun with. Stigmatized properties can include many things, and one of the things that popped up in my research were haunted houses. Now, a lot of people believe in ghosts. A lot of people don't believe in ghosts. It's sort of a fun thing, and since we're close to Halloween, I wanted to bring that part up. In Florida, since the statute didn't address this, I think you should disclose it because it's not covered. So you might be open to action if it is, but then again, how do you prove a ghost? That's the fun part. Other things that might need to be disclosed or should be disclosed are whether or not there's a sexual predator in the neighborhood. Things like that are also obtainable through the Florida Department of Law Enforcement. But if you know it, it's best to put it down. You want to try to avoid litigation at all times. Regarding the paranormal resident, as I called it, the states I surveyed, none of them require disclosure, but at the risk of litigation, I would disclose it if you knew about it, but I'm being funny here. I wouldn't want that first case of first impression on that one. There's no cases in Florida on that I found. Things other than that, if there's been criminal activity on the property that you know of, say you bought it at an auction and it was a meth lab or some other nefarious thing was going on there, you might want to disclose that because the people might be coming back to the place to fulfill whatever need they may have had and expose the new owners to, potential harm. So things like that should be disclosed as well. Getting into the claims process, let's go back to the contract. And if you look at 15B, which survives the closing or termination, it basically says if it's a seller default. And one of the things of the default is fulfilling their obligations under the contract, which gets us back to 10J, which we already talked about. And that's the disclosure. Well, that's an obligation under the contract. So you get back in there under 15B using 10J. So what you would do to start the claims process off is A, pull the contract, double check, make sure these things weren't stricken, send a demand letter out using these. And the nice thing about this is this also gets you back into the attorney's fees provision under 17, which also survives. So the sheer fact that it doesn't say 10J survives isn't a problem, because this is one of the obligations. And then you've got 15B that gets you back to it. So the first step in the process of a claim would be to go ahead and use a demand letter citing to these issues, identifying that the failure to disclose and what the actual disclosure was or should have been, and going that route. Sometimes that works, sometimes it doesn't. It's just one of those things, and you end up having to litigate from there. And that's where the case law and the courts have been struggling with this historically since 1986. Some cases come down saying that there's an obligation. Some say the obligation is there, but if X, Y, and Z, that could be fatal to the claim. So it involves a lot of research for every single one, every single time. And that's pretty much what I've got.
All right. Well, my goodness, what an amazing amount of information in this time period. You all are just incredible beacons of knowledge on this subject. And I know that the folks in the audience have just gained a lot of insight that they would not have had the opportunity to if you all hadn't come to speak with us here today. So folks, I think at this time, am I correct? Kristen, John, Colleen, we open up for some Q&A if anyone has any questions. Nothing came into the chat yet or the Q&A yet, but I know it's a lot of information, so people are probably processing. So is this the perfect time for Q&A, or is there anything more substantively that you were hoping to address?
I'm happy to give my contact information, which is if anybody has any questions about the contract or how these things work, you're welcome to contact me at my email address, and that is Sachs. So C is in cat, S is in Sam, ACHS @thefund.com.
Awesome. Thank you so much. And I've just popped that into the chat, but of
Perfect.
course, we'll include that information along with this recording, along with the CLE and the materials after the event. I will also say to folks, I did pop into the chat that access to all of the wonderful materials that we received as part of this training. If you have any issues accessing it, please let me know, although I will assume there were no issues accessing it because nobody told me.
Let me go ahead and give my contact info as well. It's John, JOHN, @jrtampalaw.com.
Awesome. Thank you so much, John. We really appreciate that.
Mine is Kristen. You can put mine in there too. Kristen @kkjlawyer.com.
Awesome. And so in the meantime, while again, I will encourage folks to please ask questions. I imagine folks are very intimidated by this subject. There are so many nuances. So don't be afraid, even if you want to ask a question that you prefer not to type. So for example, I know this subject matter might require you to express a fact scenario or something like that. If you prefer not to put it into the chat or the Q&A, you can raise your hand. I will be able to see you raising your hand, and I can take you off mute for the purposes of asking your question, if that makes it easier and more accessible for you to describe, your circumstance or what you're looking for. In the meantime, while folks are either building that confidence to ask questions or thinking about what they might want to ask, I am going to pop the CLE code into the chat. Let me get that. And that CLE code is 2310199, N as in Nancy. And this CLE code is good for 1.5 general CLE credits and 1.5 real estate certification credits. I know folks are always trying to get those certification credits. So here you have it. And with no, I do see a hand raised. Let me see. Oh, so exciting. All right, Morgan, I'm going to allow you to talk. Ready, everyone? You have the ability to unmute. You should, or did I unmute Angeline? What did I do? Hold on one second. This is what happens when I get too excited. Okay. Morgan, you should have the ability to speak now.
I think I did it. Can everyone hear me?
Yes.
Perfect. I think this question is going to go to Colleen, because you had mentioned that in your presentation. What is the position that you all are taking on the limitation for purchase for those specifically delineated countries overseas?
Well, so far for the contract purpose, we have just included the notice that says this statute is out there. There are lots and lots of questions still for this particular item. FREC is in the process of, and I believe has the other day approved an affidavit. It has 3 of the portions that we had asked them, not our committee, but actually on behalf of my company and some of the other underwriters, we had provided some affidavits that were suggested to be the affidavit that would be signed at closing by all buyers, saying whether or not they are a person from one of these countries of concern, and if they are a person from the country of concern, whether they meet one of the exceptions, because there are a couple of exceptions in this. So FREC has adopted, at least in part, an affidavit. We are now in a process where the Department of Commerce is now making rules that are for the statute and it will clarify some things. I've seen some of the rules. There've been a lot of comments on them. There are going to be some other hearings, but we don't have those rules yet. A lot of there are deadlines that are starting to come up at the end of the year for certain things, and I doubt that we will have the rules in place by then. So on that, you'll just want to keep watching. If you have questions about whether certain things apply, I would talk to the Department of Commerce, call them, say you have a question about that. You're welcome to call me on any of the things that have to do with that if you have specific questions on it. We can go over fact scenarios. But right now things are a little broad, a little open, because we don't have that rulemaking complete yet. And we're looking forward to that and looking forward to seeing if there are any changes that are going to happen with that statute. I know there will be some proposed legislation on some changes coming up at in the first session of next year.
I'm following a lawsuit that was filed in reference to this this statute getting signed by the governor, and so I'm wondering, will any of that proposed rulemaking be impacted by however long this lawsuit continues to take?
Yeah, is that the lawsuit by the ACLU?
Yeah.
We were hoping that they would put everything on hold and say that the statute was on hold until that case was decided. The judge that is handling that case decided not to put those things on hold. So they're still moving forward. The statute is there. It is effective. It was effective as of July 1st. You have to abide by it. What we're telling people is if they have a question about this, like if they have to register, because it has a registration requirement, they need to call the Department of Commerce and ask the Department of Commerce to let them know what they need to do, since that registration process is not open yet, and people need to register. So those things are moving forward. I don't see the case having any impact on what's going on until the case is finally decided, and of course it'll depend on what that decision is.
Sure. Thank you. I appreciate that.
Sure.
Thank you for your question, Morgan. I am going to just disable the talking ability, just because sometimes it gets messy. So Morgan, I'm turning you off. If you want to come back on, raise your hand. And then a second question did come in through the chat, and I am going to read it out loud. What if the broker made an error and did not include a broker fee in closing costs? Can they pursue that against the buyer after closing, or is that the mortgage broker's fault? And did they waive their right to go after the buyer for what they should have paid?
I'm happy to take this one. John might have comments too. I'm not sure if this means that the broker made an error or the closing agent made an error. I do a lot of broker commission disputes. Typically how I would say I look at the facts is I look at the broker agreements, whether that's a listing agreement or a buyer rep agreement where there's an agreement to pay commission, or sometimes an agreement to pay a transaction fee to a broker, any type of fee paid to a broker. I look at that as separate from the purchase contract, because the broker is not a party to the purchase contract. Once the purchase contract is closed, I believe a buyer, in a lot of circumstances, the broker would still have a claim. But I would say they're very, very fact specific. If there's some sort of waiver by the broker, for example, they sent an email saying that they weren't going to charge something, or there was a review of the HUD statement. As a best practices, brokers should review the closing statement to make sure everything's on there properly, but brokers don't always get a copy of it. So sometimes that doesn't happen. They should get a copy, but they don't always get a copy. But I would say for the most part, I don't think the closing of a transaction necessarily waives rights to enforce broker commission agreements in the simplest sense. But like I said, they're very fact specific. But getting all those fees properly noted on the closing statement, I think is something really important. It's actually something I have on the agenda for my real estate, for my committee at Reptile in 2 weeks. Because how commissions are being charged is something that's changing in the industry right now. There's a lot of class action lawsuits for anyone following along, where there's classes of home sellers challenging the way commissions have been traditionally charged. There's a 3-week trial going on right now in, I think it's Missouri. Don't quote me. I could have my Midwest states wrong, but it's going on right now. It's in week 2. And if that happens, there's going to be a lot more situations, I think, where buyers might be obligated to pay commissions, and they have to be aware of that. John, do you have anything to add? I know you deal with this too.
You covered it perfectly. I always view the listing agreement or the buyer's broker agreement as a separate contract, as it is, because the brokers aren't a party to the sales contract, and that's where the relief goes. So the first thing you'd have to go back is look at the buyer's broker agreement or the listing agreement.
Well, thank you both for that insight. I don't see any, and you received a thank you in the chat. I don't see any more questions that have come in through the Q&A or the chat. I think ending 2 minutes early on a Friday, that's all right in my book, if anyone is okay with that as well. Before we sign off, again, I will reiterate just extreme thanks to the real property and probate and trust law section of the Florida Bar. This could not have happened without your generosity to share this information with us, and really to just go out there for legal aid advocates to include them in all of the great things that you know.
Always glad to help.
All right, thank you so much, John, Kristen, Colleen. Before officially signing off, any last words? I know you all three have talked enough. Any last words? All right, I will take the last word and say, have a wonderful, wonderful weekend. Thank you for all that you do. And I hope for the opportunity to collaborate and learn from you all again in the future. Lots of thank yous coming in from the chat. Thank you all for attending, and have a fantastic weekend all.
Thank you.
Take care.
Thank you.